from designated brokers from around the Valley, and today is no exception. For me, I woke up and I said, boy, I'm going to be in the room with three beautiful ladies, and doesn't get any better than that. But anyways, we are joined today by Marge Lindsay, who is from West USA Realty. She made sure that I said realty with 2 syllables, and if I said it with 3 syllables, I was going to get smacked. We picked her up on the side of the road last month and decided to have her back because, she does a great job. We've got Martha Appel, who is a designated broker for Coldwell Banker, Vanessa Berman from Caliber Company, and of course, I'm your host, Mike Weinstein, with Six Figure Mindshift. So today, and I always like to make sure that I include the F on that. Every time I type Six Figure Mindshift, there's a couple times where the F wasn't included. And I'm like, boy, good thing for spell check. Well, today's topic is seller warranties and BINSR boo-boos. Now, I need to just start off by saying, and there's a lot of talk and a lot of discussion that the seller warranties are going to be going away next year, possibly with the new contract, but we're not there yet. And every single day, we're agents are facing the issue of seller warranties and how it relates and how to use the BINSR. So, do we know anything about that? Is that confirmed that we're getting rid of warranties?
Well, it's not confirmed yet. We still have we're still working on the draft. The draft will go to the AAR's Risk Management Committee on September 22nd, I believe, and then it has to go through the Executive Committee at AAR, and then we'll have the final outcome. However, it has gone out to the loop, all the revisions, and everybody was very, very pleased, or most everybody, 99% of everybody that commented on it is pleased with the idea that the seller warranties would be removed in the contract as of February of 2017.
Yeah, because it just creates a lot of confusion.
It does.
Agents we don't necessarily understand exactly what is a seller warranty. A lot of agents, including myself in the past, have not written the BINSR correctly and what goes in what part of the BINSR.
Right.
And I know for you guys as designated brokers, it's a constant battle.
Absolutely it is.
All right, so let's move right along. So, Marge, let's start with you. What is a warranted item?
A problem, which is why we're going to get rid of them. No. I mean,
Are you a warranted item?
Don't I wish. My warranty expired as I got older. But when we look at it, I mean, it's the things that are currently spelled out and designated in the contract, saying if this is something that's in there, then it is to be in working condition at the time of close. The seller, is to take care of these things. And we've worked with this. Gosh, I don't even know, Martha, if you can recall how many, many years we've had this in our AAR contracts. I mean,
back as I can remember.
Yeah, I was going to say, I honestly can't remember when we didn't have it in there. But, it's like you say, it's a bone of contention, and it's something that's created so many issues. And we're not thinking just from a broker perspective, but for the agents out there. And it's also confusing to the consumer. When it says it's warranted, well, working condition is one thing. And so it really became such a difficult thing. That's why the probability of it being removed and letting us be more specific and more definitive on what's going to be warranted in the future is being looked at so positively.
Any comments as far as how you would explain what a warranted item is to your agents, Martha?
Well, we have the specific section of the purchase contract, Section 5A, which kind of spells out what the warranted items are. And I think the issue is, like Marge was pointing out, even if one of those items is in contention, it comes down to what is working condition and what is not. We all know that the heating, cooling, et cetera, is a warranted item. And somebody says, well, my AC cools to 80 degrees, it's working. And then the buyer says, but it's not in really the way it's intended to work at 80 degrees. So that's the other contention is, okay, you can still have a working, quote unquote, warranted item, but it's not working as it's intended.
And so, and they are to work as intended.
Correct.
Okay, Vanessa, what are some of the common misconceptions that you are finding among not only some of your agents, but just agents in general out there?
lot of misconceptions comes with what is warranted and what isn't. A lot of agents are concerned with things that aren't warranted. Some still think a roof is a warranted item,
True.
and it's not. It's been taken out a long time ago. So I see that, and I see, as Marge pointed out, it's written in the wrong section of the BINSR, what is a warranted item and what isn't.
Now, Marge, I mean, I think one of the misconceptions that I see out there is, and then this just kind of brings in the whole idea of the home inspection of just some people just have the idea that everything's a warranted item. I walk into the house, everything should be warranted, you know, to the tile, to the carpet, to drapery, or whatever the case is. If it's in the house, that there needs to be some sort of, it needs to be included in this warranted item. Probably not the case.
Absolutely not the case. And like you say, there's so many misconceptions out there. And, you know, I don't know if it's just because, well, it's a combination of things. I was going to say, I don't know if it's because those salespeople have not had the training. The salespeople have had other experiences where, even though it was not included as a warranted item, they've had situations where on a transaction, somebody did, you know, take care of it. So their belief is it is warranted because in my past experiences, somebody's always taken care of it. So why wouldn't they in the future? You know, that sort of thing. It can be just a ton of information, you know, that is passed on that's incorrect, but sounds good. You know, in theory, it ought to work and this sort of thing, but it a lot of times doesn't.
Yeah, I always learn this lesson when I take my car in, the bumper-to-bumper warranty. Apparently, it's not necessarily bumper-to-bumper. I always get a quick education of truly what is warranted or not, because I think if I buy a brand new car, that everything should be warranted. Yeah. Martha?
I agree when it comes to cars. Yeah. I think the other issue, too, is you could have something like a sticking door, for instance. And so what is the problem? Is it because it's not aligned correctly, which obviously wouldn't be a warranted item? But if it's because of the hinges are off, that could be a warranted item, because that could be considered a mechanical issue. Or if the lock doesn't work, that's a mechanical issue. Same with windows, you know, sticky windows.
Or, you know, the one, too, that we hear about, and I know Martha and I heard about this at the industry partner conferences, when somebody will say that the faucet is dripping. And the seller's attitude and or the listing agent's response can often be, hey, you know what? It's still working. It's not a big deal. It's just a little drip. And they say, but we want it fixed. Well, we're not going to go fix it. And now Rick Mack even made the comment one time as our real estate attorney with the legal hotline. What happens now is we make a major to do over a dripping faucet when a 69-cent washer would probably fix, you know, the thing overall. But the question that's often asked is if you can still get cold and hot water. So there's a little bit of a drip. It's not that big of a deal. So it goes back to what Martha said. Okay, is that the way the manufacturer intended it? Is that the way it was supposed to be? And clearly the answer is no. But now you've got this 69-cent washer issue that can blow up an entire transaction because everybody wants their position to be heard and understood. And it can be difficult.
Michelle Lynn's actually come out with an article a while back, a couple of years ago, and about what is warranted, what is not. And she gave some examples in that article, and I found one of them kind of interesting. And it was actually kind of a light bulb even for me. The valves, you know, the hot and cold valves on a sink, even if they're reversed, you know, you turn on the left side, you expect to get hot water and you get cold. That's not a warranted item because there is hot water, there is cold water. So in her legal opinion, that would not be a warranted item. So it does get gray and it does get fuzzy and it does cause problems and it does, cause contention in a purchase contract. And it's just best that everything be negotiable, period.
Right. And I think agents need to educate either their buyers or sellers up front. So when it comes time to negotiate, it's clear.
So how much of and I don't know how many agents do this. I guess my first takeaway, my first tip is part of your buyer presentation or part of your listing presentation should probably include a little bit of time explaining the whole issue or projected problems with warranted items. I feel like for a lot of agents, these discussions aren't popping up with their clients until the BINSR shows up.
Right.
It's very true, Mike.
All right. Good. It's the nicest thing Marge said to me all week. All right. So continuing on the train of thought. So we can elaborate a little bit on the BINSR. Obviously, one of the common agent mistakes is not understanding what part of the BINSR a warranted item is included in and so forth. But besides that, and if anyone wants to just jump in and talk about that for a minute, that'd be great. But what are some other agent mistakes regarding warranted items?
Well, first, regarding what you said about what page of the BINSR, it was not too long ago. I want to say maybe 5-6 years ago that AAR decided to revise the BINSR and make a separate page for the warranted items versus the non-warranted items. The idea being that it would be less confusing to buyers and sellers and agents because it would be broken down. So the buyer would just put the non-warranted items on one page and the non-warranted item on another page. And so it'd be much easier for the seller to understand. Well, obviously, I think it's caused more confusion because so the question is, if a warranted item is put on the non-warranted page, is the seller still responsible to fix that item? And the answer is yes. It has it makes no difference on what page something is put on the BINSR.
Oh, doesn't?
It doesn't. It could, because the terms of the contract still prevail. So the BINSR is just an avenue, just a way of putting it in writing, having everybody sign a document regarding the disapproval of the items. It used to be in the old days, remember, Marge, I'm sure, that agents were sending emails and saying, my buyers want this fixed and this fixed and that, and that doesn't equate to the terms of the contract. So that's why the BINSR was born, was just a way to provide the negotiations.
I'm wondering if with Vanessa and with Martha, if you would say too, when we're talking about some of the agent mistakes regarding warranted items, how frequently are you seeing still on a BINSR report where the agent has written in that any and all repairs are to be made by licensed bonded contractors?
Yes.
That's one of the areas where I think, Mike, it comes in with.
We're going to talk about that in a few minutes. So,
okay.
because that's actually that's a specific question that we have, because
Excellent.
It's a huge area of contention. And most, and I always found in real estate, most areas of contention are just a result of just lack of knowledge.
Absolutely true.
Mm-hmm.
Very true. Well, what I like was, when
that's what my wife tells me.
I'm sure Mindy's right too. But when you say, that's one of the biggest areas, and I really think it is, you need to counsel, just as Vanessa said, your seller up front on things that can come about to prepare them for it, and even more, especially with the buyer, to let them know some of the things they have to look for. And it puts a lot of responsibility on the agent. But once you get used to saying that and it becomes a matter-of-fact process, oh my gosh, it's going to alleviate a lot of frustration and areas of concern.
Yeah, and BINSR's with 48 items because buyers are requesting cosmetic repairs because they weren't educated on what to ask for. Then the BINSR gets really long.
Yeah, and then that also goes to the other question: how does an addendum? Obviously, at some point, there's just not enough room on the BINSR for a lot of these mistakes. So, if you use an addendum, a continuation of it, do you put on the BINSR C addendum for continuation, and then is that addendum numbered like a true addendum? How does that work?
I say absolutely. You have to
Yes.
tie the two together. And on the BINSR, say C attached addendum, and the addendum should be actually called an addendum to the BINSR. So it doesn't get lost in the paperwork shuffle of the transaction. So it has to be somehow tied together. And because, sometimes buyers will ask for everything, which they can. They can ask for anything, whether it's cosmetic or not. But it's just going to frustrate the seller much, much more than just being okay, let's get down to the real nitty gritty and what we really want to fix here.
Yeah, because I've always and this has just been a personal philosophy, we're negotiators and I throw in everything into the BINSR knowing that we're not going to get everything. And that's what I always explain to my buyers. We're not going to get everything, but the more that we ask for, the more of those items that we're going to get.
Mm-hmm.
And then what about when people put on the BINSR see and repair items listed in the home inspection report?
Ugh.
No.
That's lousy. to
It's
say.
lazy.
bad.
It's lazy is
Yeah.
what it is.
Yeah, lousy, lazy
Yeah.
practice.
And we see that a lot. And it just, because the inspection report can be vague. And so you don't know, you have no idea what they're even asking. You know, like I just recently saw an inspection report, and the inspector said, well, I check the lights in the ceiling fans because they're not working. Could be a light bulb. Okay, so what does that mean?
Yeah.
So, yeah, that's to me just plain laziness. They just see attached to inspection and they just attach the report right to the BINSR.
And what I would do as the seller, I would just reply back, all right, check
I
the
read
light
it.
bulbs.
Yeah.
Okay, then they'll say, well, they're not working. Didn't matter. You told me just to check them.
Right,
And
exactly.
I checked them.
Right,
Well,
right.
and my feeling is when they say see attached inspection report, which could be 20 pages, it could be 48 pages, it
Mhm.
could be any number of things. Okay, we've seen it, we've received it. You didn't ask for anything. I'm not an interpreter. I
Right.
don't have to try to figure out what that buyer and or the buyer broker intended with that. And so when somebody does that, I think the seller is absolutely legitimately bona fide in saying, okay, so we checked it, we saw it, thank you. Contract says you were to provide it, you did, period. But they didn't ask for anything to be done.
Right, right.
So there's
exactly.
nothing that the seller's obligated to.
Mhm.
Right. And it gets confusing too when they just do that, because a home inspection report has the general report and then a summary. So what item numbers were you referring to? Summary items or in the additional report? The thick part.
Right. Yeah, that's a
Mhm.
great
Good point.
great point. All right, we're gonna kind of throw out some specific scenarios, and we're starting to get some questions in. So we'll start with this one that's not going to be on the PowerPoint slide from one of our listeners. Is a fire door from garage to house that's not self-closing considered a warranted item? Let's say it's just not self-closing, and
Oh,
it
that's a
doesn't
good
close
question.
all the way, and it.
I think it depends on why it doesn't close all the way. Like I mentioned before, is it because if it's a hinge problem, then it could be a mechanical item. If it's a doorknob problem, it could be a mechanical item. If it's just sticking because it's humid out, then it's probably not a warranted item. And even though it's quote by code, that doesn't make it necessarily a warranted item either.
That's a good point. And see, because you would assume, and then that would let's just bring in then latching pool fences,
Right.
and or the door that goes out to the backyard by for many cities it's a city code
Mm-hmm.
that these things have to be operational, but just because it's code doesn't necessarily make it a warranted item. Is what
Correct.
you're saying?
Right.
Correct.
All right. Sticking interior door that will not lock.
I think we pretty much covered that already.
Yeah, and then this is the other one. I want to talk about this one
Oh,
for a second.
wow.
Hot and cold sink valves that are reversed. See, now, from what you said earlier, Martha, I would say that the manufacturer intended that if this valve is red and it says hot, then the hot water should come out of it, even if they're reversed. To me, from what you just said, I'm thinking that that's not what the manufacturer intended.
That was just in Michelle Lind. Obviously Michelle Lind is
A lot smarter than I am.
a lot smarter than all of us. And, that's exactly what she said in that article. I think there could be an argument about it, especially if they're marked, like in your slide where they're actually marked. But a lot of times they're not, like in your bathrooms, they're not necessarily marked.
Oh, yeah, that's a good point. All right. Anyone else on that one?
Nope, I agree
All
with
right.
Martha.
Let's see. Window seals.
Crickets.
Crickets? And if they're sealed properly, you won't hear the crickets.
Right. Exactly.
So do this, a lot of times the windows don't seal properly, or let's say that you have a window, a double pane window, and it's not cracked necessarily, but you can tell when it's been compromised and the air inside has been compromised. That would be something considered a warranted item? I mean, the window's intact.
I
would
would
say
say no.
No, I agree.
Yeah.
No.
Yeah.
All right, so let's move on to kind of what we've been alluding to is the BINSR. And so I'm just going to throw out a few questions, a few scenarios, and let's just we'll start with you, Marge, on this one, and then everybody else can jump in. So what if a buyer submits and I want to just stop again, Martha. Your explanation of what the purpose of the BINSR was spot on. I mean, I think that helps us understanding what is the purpose of the BINSR, and it's just a conduit. It's just a way to bring the inspection report and the purchase contract together so that everybody knows, what's expected.
Right, and it's not even required. It just, even the contract says it's available. It's not required.
Do brokers require it?
Some may. I think that's going to be an individual broker policy. You don't have to have a commissioner's rule or anything in the code of ethics or statute for the company to say, well, I can't do this, I can't do that. Individual companies have the right to establish their own policies. And so I'm sure there are some brokers out there who say to their agents, when you're working with a buyer, our company policy is that you must have the BINSR report.
And it's a standard of practice in the industry now.
Yeah, that's exactly where I think it is. It's more the standard of care, where people do expect it. And so it could bite an agent in the backside if they don't have one, if they find themselves in a litigious situation of some sort.
And even with the assuming the seller warranties are taken out of the contract, we'll still have a BINSR. AAR will still have a BINSR because there doesn't have to be, but it's an easy way for the negotiations if people are familiar with the form that is being used.
Yeah, and it's a heck of a lot easier for our agents to fill out that form, even though you question it when you read it, the way it's filled out sometimes, than to try and come up with all of the wording to state the same things that BINSR report does address.
All right, so Vanessa, this has to be an agent beware issue. So now that we've learned that the BINSR is not necessarily a requirement, as an agent, don't take that as a license to not if you don't feel like offering your buyer an opportunity to use the buyer to not. I mean, you better be letting your agents better be letting their clients have the opportunity to know that the form exists, right?
Absolutely. You get yourself in a lot of hot water.
Exactly.
Unless that valve's not working. All right, so what if a buyer submits the BINSR stating that they wish to cancel, but they do not list a reason?
That's so irritating. The reason it's irritating is the agents are not reading the form. It says the following items are disapproved or something like that. But it says, if you read it like a sentence, you have to have something on there. The following, we're canceling. They mark the canceling box, and due to the following item or items disapproved, and then they write in, we're canceling. That's not even a sentence. It's like if you read the form and followed grammatically, you'd put in a reason.
Well, it's because everybody's tweeting and texting. This is how we speak now.
That's very true. Exactly.
And that's why they're going to get themselves into a jam. I've seen many times in expert witness issues and or cases where the argument has prevailed saying, okay, you didn't give us anything that you disapproved. And when they write something in canceling per contract, okay, well, contract doesn't say that, so now you've got to go back and say, okay, show me what you're talking about. And it isn't there. If they don't list a reason, seller can ignore it and they're not going to be able to legally cancel based on what they submitted in that BINSR report.
Are there any reasons? How much leeway do we have on the reasons? I mean, is there? Is
leeway.
Is it as simple as I don't like how tall that tree is?
Yeah. I mean, it really could be.
It has to pertain to the premises, though.
Exactly.
Yeah.
And and to this extent, I saw one time where one of our agents said, well, they can't cancel for this reason. It said it's on a noisy street. And I said, yes, they can. Well, no, they can't. I mean, it was on the same noisy street when they saw it, and it was on the same noisy street when they wrote the contract. So that shouldn't be a basis for, not proceeding. And I said, okay, but what if it was shown on late Saturday afternoon and there wasn't any real traffic out there? Now they go back on a Monday and find out that this is a thoroughfare. Now you've got a lot of traffic, here's some noise that they weren't aware of. So that is a basis for cancellation. I mean, I agree with Martha and Vanessa. I mean, it's something that should be related to the property, but it could be something that simple. And if they say, well, I've got 50 reasons. Well, it could be as simple as saying that the cost for remodeling and repair or renovation is far greater than expected and we can't afford to do it, we therefore are going to cancel. You don't have to list those 50 things.
What if the reason that I'm canceling can easily be remedied by the seller? Let's say I say, we're canceling the contract because we don't like the tree, because it's too close to the house. But that's something that the seller can come back and say, well, okay, well, we'll go ahead and fix it. Would that impact the cancellation?
No. They still have the ability to cancel. It could be, they don't like the color of the carpet, or they don't like the color of the paint in one of the bedrooms. They could say, the backyard faces east or west or whatever the case is. It's and we all know that the word reasonable used to be in there. Reasonable cancellation.
I didn't know that we took that out. That's funny.
And thankfully we did, because that's such a subjective word that what is reasonable to one person may not be reasonable to another.
Right.
I mean, we had a situation where the next door neighbor's family car was an old hearse, and it freaked out the buyer, and the buyer canceled. And my agent called me and said, well, that's stupid. I said, that's reasonable to them. And so, you just, but it has to have something to do with the premises or the surrounding area. You can't say, we just lost our job, for instance. The buyer can't say, well, I just laid off or whatever that's.
Yeah. I'd like to bring up too that, these sellers agents and sellers are savvy, and earnest deposits are being held by the seller and they're disputing their cancellation. So you need to be aware when you're not putting a reason, you've jeopardized the money for your buyer.
We're looking for reasons to be able to keep the earnest money.
Absolutely.
All right, so I'll put everybody on the spot. What's the funniest or craziest reason that you've seen a contract canceled over?
I think it was my hearse story.
Yeah, that's a good one. I like to, when I do them, I like to get as creative as possible. I just got like a pinwheel. We just, spin the wheel and see what excuse are we going to use. And they're all, no, I'm just kidding. I don't do that.
Huh. I haven't had one as good as the hearse.
Me either.
Yeah.
Can't top it.
Yeah, we're going to give Martha the trophy on that one.
All right. A specific question came in for Martha, and I'm excited about this question because anytime that we get questions that I know I can answer, that's a good one. All right, Martha. This agent sees agents using addendums to cancel contracts. What form should they be using?
Oh, that's a great question. Actually, my company just came up with, or I came up with a notice form. It's called a notice. And we've had it out now for about a year and a half, because what agents were doing to cancel is using an addendum, because there is no other AAR form out there. And so I thought, well, that's kind of crazy, because there are certain circumstances in the contract where there has to, number one, be a notice of some type, or let's say the HOA docs come and the buyer finds out that the HOA is very close to bankruptcy and they want to cancel. Where do they cancel? Because it's not a BINSR item. So I felt that it was necessary to have some type of unilateral notice form that a buyer could cancel a contract based on whatever. I mean, it could be, within the terms of the contract or not.
All right. What if this is totally off the subject here, but my mind gets going. So let's say we're past the inspection period, and we everybody had signed and executed the HOA addendum, and then the buyer finds out that the information on the HOA addendum was not accurate, whether it was just a monthly payment or whatever the case is. Is that a right to cancel?
I'd say no. If it's past the inspection period, be my opinion.
But the original contract, the original HOA addendum, the information wasn't accurate provided by the seller.
Well, but you're supposed to investigate and do your discovery and so forth during the inspection period.
Right.
So you're going to have an argument, Mike, on both sides. You're going to say, well, you gave me misinformation. They're going to say, well, I believed it to be true at the time I gave it to you. You, however, should have checked it during the inspection period. You didn't. Therefore, you've given up the right to cancel on, this basis. And I mean, that's an attorney's dream, because you're going to feed two of them, as they, try to sort this out and decide whose argument's the strongest and who's going to prevail.
I agree with Marge. It says right on the form, buyer's due diligence on the form, on the HOA form, specifies it.
Oh, okay.
That's correct. It does. I just want to throw one other thing out talking
Sure.
about if a buyer wants to cancel, not using an addendum. An addendum is a bilateral agreement to amend the terms of the contract. So that's the other reason why you don't use the addendum to unilaterally cancel, because an addendum has to be signed by both parties. And that particular situation, most likely the seller is not going to agree to the cancellation.
All right. What happens if the buyer submits a BINSR to the seller and the seller does not respond within the 5-day response time? That happens all the time. It creates all types of problems and confusion for our agents.
Yeah. So you can either contact the listing agent and write up an addendum to extend the inspection period, or you take that as a non-response and they are not doing any repairs.
Okay. And then what happens if you send the addendum, but the seller doesn't sign the addendum?
Well, I mean, for the extension and so forth. Well,
Yeah.
the contract is really clear. I mean, it honestly is. I always refer to it as the 10, 5, and 5.
Mhm.
You know, you've got 10 days, Mr. or Mrs. Buyer, to submit whatever you want during that inspection period. The seller then has 5 days in which to respond. And the contract will tell us if the seller does not respond, because it says they should respond in writing. If they don't, then it's conclusively deemed that they're not doing anything, but the clock continues to tick. So when we get to the end of that 5-day period, the seller has said, I'm not doing anything. Now the buyer has the final 5 days in which to decide, am I going to go ahead knowing the seller's not going to do anything, or am I going to cancel? And that must be decided within that last 5 days. So the contract honestly is the best source to go to there, because it tells you specifically what's going to happen, unless, as Vanessa says, you put something in writing, and if they don't respond, you're still having to go with what the contract says.
Business days or calendar days?
Contract
Calendar
is very clear.
Calendar days.
Okay. So I'm a buyer's agent. We submit the BINSR, okay, and the seller's got 5 days to respond, and I deem that they're not going they haven't responded, so I deem they're not going to make any repairs. Does the contract have to be canceled by the end of that 5th day?
By whom?
By the buyer. If the buyer
no,
says
the buyer has 5 days after that. So, so you're saying in that last 5 days, do they have to cancel
okay, so
within that last?
I submit a BINSR.
Okay.
Okay. The seller has 5 days to respond to my
Right.
request.
Right.
Doesn't even respond in this
Right.
scenario.
Right.
Do I, as the buyer, have to then cancel the contract by the end of that 5th day?
No.
Okay.
No, the buyer has 5 days after the seller's response or
Oh.
non-response to make
After
a
the
determination.
expiration of the 5 days, they have
Yes.
another 5 days.
Okay, that's good. Okay. All right. If a buyer cancels on the BINSR, do they still have to send the inspection report? So let's start with this question. Is the buyer required to send the inspection report to the seller?
Yes.
Yes.
Okay, so if they're going to cancel the BINSR, do they have to provide the inspection report?
Yes.
Yes.
Contract, the BINSR isn't mandated, as Martha said in the very beginning, but the contract is very clear that the buyer is to provide at no cost copy of any and all inspection reports. So yeah, they still have to do it, and it's not predicated on whether or not they, submit a BINSR or come to an agreement or non-agreement.
Vanessa, can I cancel as the buyer? Can I utilize the BINSR to cancel a contract, even if I don't get an inspection?
Yes.
What do you do as the buyer's agent if the seller refuses to fix a warranted item? So let's just say they've agreed to fix. Well, okay, they just refuse to fix a warranted item, and maybe it was even submitted into the BINSR that they would do it, but they just decide, hey, we're not going to do it, and we get close to the close of escrow, and they haven't done it, and they're not going to do it. Where do we go from there?
I think it's called a 3-day cure.
Right.
You send them a cure notice.
That's the reason why you want to make sure that all the receipts for the repairs are done 3 days, or given to the title company 3 days prior to the close of escrow. So if they're not, then you do the 3-day cure notice, which brings it right down to the close of escrow date. But even if, let's say it was the day before, and the buyer does their walkthrough and they find out the seller didn't do some of the repairs, they would still issue the cure, and potentially the buyer could actually extend the close of escrow until the end of those 3 days.
And so, and if the seller still refuses, then at the end of it all, the buyer has two decisions to make. Either, okay, fine, I'm going to accept the fact that they're not going to do it, or I cancel the contract. Is there any other remedies for the buyer?
Yeah, I mean, there are several things. And sometimes if it's just, let me go back to that 69-cent washer. I think the buyer is going to be hard pressed to be able to cancel on that basis. Because now you're going to, I think the strongest position for an attorney is one that says, no, that's frivolous. That's something you can't do that. But when you say, okay, is there a fix? They can go ahead and close. They can fix it. They can go to small claims court. And that's where I would recommend, if I were, that broker for them, or even that agent, is just tell them you take it to small claims court, and you're going to be real strong. You've got the contract that says they were going to do it. You've got the other documentation. You now have the receipts, because many times they have to go ahead and get it fixed in order to do it. One example I think of is when they leave a lot of trash and a lot of debris and broken down cars, and and they haven't taken them out. And you see agents who have said to their client, go ahead, haul it out of here, take care of all of this, keep all of your receipts, take the contract and the documentation, go to small claims court, assuming it's $3,500 or less, and let the court, make that award.
And I'll just provide some not personal advice, just some great advice. If you do go to small claims court, do bring a copy of the contract, because you can't assume that judge or that panel has ever seen a real estate purchase contract before. And without it, they can make decisions based on their own personal opinions, but not understanding what's in the actual contract.
Correct.
Right.
All right, here's an interesting question. What if the buyer receives the CC&Rs after the executed BINSR? The buyer does the buyer still have 5 days to review the CC&Rs and opt out?
Yes.
Yes. CC&Rs, the HOA docs are not tied to the inspection period.
All right, that was a good one. All right. If an as-is addendum has been executed, can you ask for warranted items to be repaired on the BINSR?
Yes.
Yes, sure.
Absolutely.
Seller is not required to fix them, but the buyer can certainly ask for them.
See, I had one of my agents. She got really upset over this because she was representing a seller, and she made it very clear. She had multiple offers, made it very clear that my seller is not going to repair anything, doesn't have the funds to repair anything. Agent submitted an offer, signed the as is, said, we understand this. And then she got upset that within the 10-day inspection period, all of a sudden the BINSR came along and thought that agent was being shady. And, maybe not, but that's the rules of the game. And so for some agents, they're telling their buyers, listen, it says as is, doesn't mean we can't. And so let's have the strongest and best offer by signing the as is addendum. But hey, when push comes to shove, we're going to ask for a ton of stuff.
Yeah.
Right.
That's just misconception of the as-is addendum.
Absolutely it is.
Well, and shame on the agent if that is the agent saying, here's what we're going to do. That's not the spirit. That's not the intent.
That's true. And that's true. But there are, let's just call a spade a spade.
Yeah, but I would just say to my seller, don't get upset. I mean, let them ask for what they want to ask for, especially in the multiple offer case that you're talking about. Let's just tell them no, and either they proceed as was intended, or they have the right to cancel. We'll just sell it to somebody else.
Yeah, the buyer still has the right to their inspection period, and they still have the right to cancel. So whether they ask for some repairs, the seller says no, and the buyer cancels anyway, is no different than them just plain out canceling during the inspection period.
All right, here's an interesting question back to the small claims court. Why small claims court over mediation? Okay, so I'm going to get into a buyer and a seller are going to get into a battle over funds, and it's got to go to somewhere. What is the progression? Is it just naturally small claims court? Are there other mediation forms? The thing with mediation, I guess the way that I understand it, both parties have to mutually agree. Small claims court, I just go in and file a claim and you get served.
Well, keep in mind, though, even though the contract does talk about mediation, there are exclusions to mediation, and one of them is if it's the 3,500 or less, because it's faster, it's quicker, it's easier, and sometimes they're looking for that resolution now versus something else.
And it's less expensive.
Cost.
Expensive, because mediation can be very expensive. Even though it says that the parties are splitting the cost of the mediator, if you're paying $250 or more per hour for that mediator, and the mediator has to spend 2 or 3 hours preparing for the mediation then goes for, let's say, 5 hours. So that's 7 hours. I mean, that could be way over the amount that you were even going for, the buyer was even asking for.
All right, the next one, we see this, and it's an interesting question, because I think sometimes we write hypotheticals into the BINSR. And is this a hypothetical, and is this a proper way to, and I understand the intent of this. We all understand the intent of it. But what if the BINSR states seller to have termite inspection performed, have termite treatment done, and if termites are found, include a 1-year warranty?
That's renegotiating a purchase contract.
What do you mean?
Well, number one, it's asking, the buyer's asking the seller to perform an inspection that the buyer should have had done during their inspection period. Then they're going on to say, okay, if they have termites, to treat it, and if termites are found, include a 1-year warranty. That's adding another provision or another term to the purchase contract, and the place for that is not in the BINSR.
Right.
Other hypotheticals we sometimes throw into the BINSR. I mean, let's talk about that for a second. Sometimes we can get really creative as agents. And I mean, when you're writing a contract, it's the who, what, when, why, where, and specifics. But are we seeing hypothetical situations, and is there a place for hypothetical situations in the BINSR?
I see it with like either AC or roof. They're asking for an inspection. They're asking the seller to complete an inspection and a repair. And
that's coming right from the inspection report. You know, the inspector will say there's something wrong with the roof. Advise it be inspected by a licensed roofer, and so they just throw that on the BINSR. When again, the seller's not doesn't have to have any further inspections done. It's up to the buyer to have done.
And what that broker needs to understand is just on that flash page, the very front page of the purchase contract, it talks about several inspections if these things are important, and one of the things there is roof, because so frequently buyers are told that an inspection report, singular, an inspection report is sufficient, and that seldom is the case.
Right.
I mean, if they want information on the roof, like Vanessa said, that was taken out of the contract, I don't even remember how many years ago,
Right.
Long time. It hasn't been there forever. And yet you'll still have say, well, the roof has to be watertight. Oh, okay. Show me where it says that, because it doesn't exist. You know, so whether it's roof or sometimes, you know, other issues like the sprinkler system, typically those inspection reports are for the home or things right in the home. So, you know, a lot of times agents are misleading because they honestly are not aware that that's a problem.
Mm-hmm.
Why isn't the roof included?
Because
you would think that, you know, if I buy a house, I got 2 little kids there, that I want the roof should naturally assume to be working.
Well, and I think that's reasonable. But what we're saying is that the typical home inspection does not include the roof. And it'll state that with most of those home inspection companies. And if you want, they'll say basically, if I see chipped tiles or broken tiles, or if I see missing asphalt shingles or something of that sort, I'll point that out. But if you want to know about the structural integrity of that roof and or the condition, then hire a roofer, because that's their area of expertise. So it's reasonable, but like they said, it's to be done during the inspection period. And if you wait till the 10th day when you submit your BINSR, you're outside the inspection period at that point, and you get one bite of the apple. You can't go back and do it again.
Right. Right.
Not Martha Appel. Just on me.
It's APPEL, by the way.
Yeah.
All right. Can the buyer submit an addendum to the BINSR in response to the seller's BINSR response to continue to negotiate repair items the seller refused to complete? How does this, if it does, affect the buyer's 5-day time frame to potentially counsel? So this is a matter of BINSRs going back and forth and so forth.
You've got 10, 5, and 5. So the buyer has 10 days after the contract acceptance to submit their their requests for repairs, if any. The seller will then have 5 days after receipt of that to decide, am I going to do it or am I not going to do it? And if I were to use an illustration, let's say that the buyer asked for 5 things to be done. The seller, during that 5-day period that they have, sends a response back and says, I will do 3 of them, not 5. The buyer now has that last 5-day period after receipt of that notice to decide, am I going to accept what the seller said or am I going to cancel the contract? Per the terms of the contract, that those are the 2 options that they have.
So there's
Not
no
to go
counter.
back.
There's no counter.
Correct.
Okay.
The 2 options in the contract are accept what the seller offered and or said, and or cancel the contract. What we do see, and I hear this a lot, and I'm sure Vanessa and Martha do too, is where they say, well, I will just counter back and say, hey, if you'll do the 4th thing. Well, there's no provision in the contract that allows you to counter back. You have 10, 5, and 5.
And it really, as far as if I'm a buyer or a buyer's agent, it's a little unfair that the buyer makes a request, the seller responds, and the buyer can't say anything else other than, okay, I'm either canceling or moving forward. So I would always say to a buyer's agent, pick up the phone, which is an old anomaly that people are forgetting about. Pick up the phone and call the listing agent and see if they can negotiate whatever that the issues are. And then obviously if the seller does agree to fix one of the other items, then you would put it on an addendum to the contract.
There are a couple of things that I come, because this happens to us a lot, Mike. It really does, where they're constantly going back and forth. And I hear agents always say, but you know what? We did counter back and they responded and we continued negotiating and it worked. Well, my immediate response then is, if you've got 2 people doing it wrong, thinking it's right, and it's not illegal, and they're all happy, I don't care. I mean, so that's good. But what you don't want to be is the buyer broker who thinks you're going to be able to continue negotiating because that's been your history with others, and find, oh, I've got this really sharp listing agent over here who says, sorry, time's up, can't do it.
Past your 5 days.
You're past your 5 days, and here's what's going to happen. Because that sharp listing agent, as I'm painting the picture, is going to prevail. Now, one of the things that I think we could do, even though you've got the 10, 5, and 5, if you really want to protect your client, so you say to the buyer, okay, the seller's willing to do 3. They're not willing to do the other 2. Well, let's counter back. Well, the contract doesn't allow us that provision. So let me ask you, me as the buyer broker, let me ask you, Mr. Mike, the buyer, if the seller still refuses to do those 2 items, do you want to cancel and get your earnest money back? Or are you going to go ahead and proceed? And if they say, no, I'll go ahead and do it, I just want to try. Okay, then here's my recommendation. Go ahead and do it and go ahead and proceed, because if you go back, you're outside the time frame and you're going to be stuck with it anyway. And or if they have another offer, they can just flat refuse and here's how it is. But if you're going to go ahead with it anyhow, that's it. If, however, that buyer were to say, no, if they won't do it, I want to cancel, I'm out of here, then you need to cancel now and tell them in the BINSR you're canceling now and why, and request a refund of the earnest money. Now, what you can do then is you could send a cover letter, or actually you could even write it into the BINSR if you do it right, and say it's, with regret that the buyer chooses to cancel the contract and is requesting an immediate refund of the earnest money. Buyer does, however, want the seller to know that if they were to reconsider and if they were to do this item, the seller or the buyer would withdraw that, the cancellation, reinstate the contract, and be willing to proceed.
But they have to be willing to walk away.
Yeah.
Yes.
I mean, if that's the case, but then you protect the earnest money.
Well, it comes down to how badly does the buyer want to buy and how badly the seller wants to sell.
Exactly.
And, sometimes agents get in the way of that. They want to make a point. They want to stand on principle. When you've got to buy, the agents say, well, you don't want to do this. You don't want to do this. Well, I want the house. Well, you should hold off. You should, let's not play all your cards right now. But I really want this house. Yeah. So sometimes agents have to just get stand back and let the buyer and seller decide what they want to do.
Agreed. Agents tend to get very emotionally involved,
Mhm.
and instead of letting the seller decide if they want those repairs, the agent is saying no.
Yeah.
Right. Agents blow probably more deals than buyers and sellers do.
What I would do in the situation is, if I'm representing the buyer, okay, we do the 10-day inspection period. Okay, we send over the BINSR. Okay, 5 days later, we get the BINSR back saying seller's only going to fix 2 items. Okay, my buyer now has 5 days, 5 more days. Why not on day 1 just send over an addendum saying, hey, seller agrees to fix these other items. I've still let them know that we're serious about it, but the seller still, and I've got now 5 days still to let the seller respond, but I've kind of put them
Sure.
on notice. And if they sign the addendum, then we're all good.
You certainly could. Absolutely. We could do that.
You're looking at me like I'm crazy, Marge.
No,
Or
no,
you're
no.
impressed. You didn't know I had that in me.
No, I didn't.
Here's a thought. What if the buyer's agent sends the addendum prior to the BINSR? So you could actually do the negotiation up front even before the BINSR is done. And that way the buyer knows prior to them submitting the BINSR essentially what the seller's position is going to be.
And then if the seller signs the addendum agreeing to everything, you don't really need a BINSR then, necessarily, because you got an addendum.
Well, if nothing else, you'd use the BINSR to confirm that they're going ahead with it, maybe now without requested repairs or something of that sort.
All right. One of our agents wants to know, how come the front page of the BINSR has no signature line?
Because it's an offer.
Okay.
The front page of the BINSR is just or I shouldn't say an offer. It's an offer from the buyer to the seller to request repairs. So there's no reason to have a signature line on the first
All right.
page.
I just saw a cancellation on the BINSR, but the next day the seller agreed to the buyer's request. Then the buyer decided to uncancel, and the buyer's agent did that on a BINSR. Can all that be done on a BINSR?
No.
Not legally. Now, again, if you've got 2 people doing it wrong, thinking it's right, and everybody's happy, go for it.
Right.
But
right.
the answer is, I agree with Vanessa and Martha both. The answer would be no.
I've seen this on a BINSR, and I just like to point it out. They ask for the buyer's agent writes up they want these 4 repairs, or they say, or we'd like a reduction in price.
All right.
That's
Or
where
in
we're
the-
headed.
We're getting
Yes.
into
Yeah.
that one next. We're getting
Okay.
into that one next. What about when? Okay, this is, you probably have seen this a million times, but somewhere along the lines that buyer and seller can't mutually agree on a repaired item, and the agent is willing, or both agents are willing to kick in part of their commission.
Mm-hmm.
Does that ever get included on the BINSR?
No.
The agents agree to reduce commission by X amount of dollars for said repairs.
No.
Shouldn't be.
Shouldn't be.
Absolutely not.
Where do commissions get renegotiated?
Between the brokers. Commission should not even be on the purchase contract.
We have a form.
Okay, another question then. If me and another agent, if Vanessa and I, she's listing, I'm buying, and we decide to do something different halfway through the escrow in reference to our commissions, as long as the total commission amount doesn't change, do buyers and sellers need to be notified?
Buyers and sellers don't have anything to do with that.
Right.
Lenders need to be notified.
If you want to get paid. Okay. All right. So let's get to this one here. What if the buyer submits a BINSR that states, in lieu of repairs, buyer requests the seller to contribute $2,500 towards closing costs? And this is a great question. There could be different forms of this, because we also now we're battling our lenders, because our lenders need certain things written certain ways so that the title company doesn't note things certain ways, so it doesn't hold up the lending. So I'm going to let the 3 of you just go.
No, you can't write it like that, because again, the contract says that the buyer will give the seller, the opportunity to fix any of the disapproved items. So you can't just say on a BINSR, okay, in lieu of that, give me money. or credit towards closing costs. But what you can do is say, okay, here's my 10 requests for repairs, and then say, but in lieu of the seller fixing those repairs, buyer requests seller to contribute $2,500 towards buyer's closing costs. The problem with that is if the lender sees that, they're going to have an issue with it.
But that's the thing. The lender doesn't necessarily see the BINSR, but they have to see all addendums.
Correct. So if they decide to go the contribution to closing cost route instead of doing the repairs, then on an addendum, you don't want to say the same thing. In lieu of repairs, just say seller and buyer agrees that seller to contribute $2,500.
So it's the in lieu of repairs.
Yeah.
It's that's
right,
creating
the red flag.
problems.
That's the red flag.
And you got to be careful what those repairs are. You know, you can't, if they're small things, that's, okay, but you're on a slippery slope when it's a big repair.
All right. Yeah, we see that one all the time. All right. We got a few minutes left, so let's just open up the floor for just additional considerations, maybe some things that we haven't hit that the three of you think that we should talk about.
Well, I think, just to stay on this last subject here for just a little bit, it is something, Mike, you're correct when you say we see that all of the time. But it goes back to what Martha said a few moments ago, and that is when you're using the BINSR to renegotiate the terms of the contract, that's not appropriate. And you've got to find another way to do it. I mean, if that's what you want. Because one of the things that can often happen too is they say, okay, in lieu of repairs, we're going to give you $2,500. So now the buyer, after closing, comes back to the seller and says, hey, you were supposed to repair these things and it isn't. Well, that's why I gave you the $2,500. No, you gave me $2,500 towards this, but you were supposed to fix this. And this was a warranted item and this and, one thing and another. It really does create a lot of issues.
All right. We do need to get to this because I teased it.
Okay.
Using the term licensed contractor.
Oh, yeah.
Uh-huh. Okay, and it's real simple. When we write into the BINSR that they are to use licensed bonded contractors for the repairs, again, is renegotiating the terms of the contract. That is not appropriate. The contract has already addressed it, saying that the repairs, if any, are to be made in a workman-like manner. So they can do it themselves. They can hire a handyman or someone else. The exception there is if and when the repair is going to cost more than $1,000. Now the registrar of contractors says that it has to be a licensed contractor. So there you wouldn't need it. But for anything under that, they can do it themselves. They can have a handyman. They can have the brother-in-law or whomever they want to do it.
The issue, though, is when a buyer's, in fact, the new word du jour that I'm seeing a lot in BINSRs is certified contractor. What the heck does that mean? There's no such thing as a certified contractor. They're trying to not use the word license, but that's really what they mean. But so what happens if the buyers or the seller says, no, I'm not going to have these items done or performed or repaired by licensed contractor? The question then comes down to, can the buyer cancel because the seller said, I'll do them, but I'm not going to use a licensed contractor? And it's my understanding that the answer is no. They can't cancel just due to the licensed contractor issue or question. Just like Marge said. But if the seller agrees to those repairs and how it was written on the BINSR using licensed contractors, then the seller has agreed to use a licensed contractor.
Any parting words, Vanessa?
None.
All right. One more quick question. Someone's just maybe just a yes or no on this one because we're running out of time. If the home inspector returns to the property to check on the status and workmanship of the requested repairs in the BINSR, is that considered the walkthrough for the buyer?
No.
Yeah, I would say no.
Well, it says walkthrough or walkthroughs. So that could be a separate, but it's not the walkthrough.
Martha, thank you.
Thank you,
Vanessa,
Mike.
thank you.
Thank
Marge,
you.
thank you.
Our
Martha And Marge, thanks for behaving yourselves. I was a little worried when we got started with the two of you.
Good thing he put us on opposite sides of the table.
Yeah, so a few six-figure mind shift announcements coming up. We've got our big entrepreneur summit coming up Thursday, October 20th. We're going to send you a link right now. We're pretty really excited about this. You can still get in for $29. We got some big names. We got Russell Shaw, Joshua Smith, and a whole host of industry leaders and leaders from outside the industry. Would love to have you join us. I will guarantee you will walk away a changed entrepreneur. So that is coming up October 20th. Also, our next free six-figure mind shift is coming up. Huge area is content writing. Just because you have a Facebook page and just because you're blogging doesn't necessarily make you a great writer. So we're going to be bringing in one of the industry's best, actually my wife, but she travels the country. She's a published author, speaks on this, trains companies such as Facebook, Fandango, HBO, and so forth. So this is a free event. We're going to send you a link to this as well, a chance to hear from somebody who trains people around the country on how to write captivating content. Everybody's got a Facebook page now, so now you want to be engaging. Everybody's a blogger. You want to write your content in an engaging way. And then lastly, we'd love for you to join our digital community where we send you just weekly blogs on real estate entrepreneurship, and so forth. You can register there at sixfiguremindshift.com. We appreciate everybody joining us this morning. And lastly, our next Broker Roundtable will be Friday, September 30th, 2016. And you will later on today or at the beginning of next week, you'll be getting an email from me with a link to this webinar that you just listened to today that'll be on our YouTube page. Appreciate everybody joining us. Again, Marge, Vanessa, Martha, thank you for being with us. Have a great day.